Welcome to today's deep dive, everyone. We are setting out on a very specific mission today.
A very complicated mission, honestly.
Yeah, totally. We are unpacking the unique financial and legal realities of second marriages and blended families.
Which is a huge topic, whether you are prepping for a new chapter yourself or actively blending a family right now.
Right, or even just trying to get your own affairs in order. This discussion is really geared toward helping you understand the stakes.
Because the stakes are incredibly high.
They really are. And to do this, we're drawing on a comprehensive guide provided by Weddizer. Now, they're a modern wedding planning platform.
And just to be clear, we aren't endorsing their platform or, necessarily their broader philosophy.
Exactly. We are just utilizing their framework today because it maps out these complex legal and financial intersections incredibly clearly.
It really does. They present this stark reality that successful marriages start with a secure financial foundation.
Right. Not just like picking out floral arrangements and venues.
Yeah, exactly.
When you think about a first marriage, financially speaking, it's kind of like building a brand new house on an empty plot of land.
Right. You are starting from zero.
Yeah, you and your partner are standing there, pouring the concrete foundation together. You lay the plumbing side by side.
Every single brick is placed as a team from the ground up. The blueprint is entirely yours to draw together.
Exactly. But then you look at a second marriage or the blending of two families, and suddenly that empty lot is completely gone.
It is no longer new construction.
No, it's more like you are trying to connect two entirely different historical buildings.
Complete with their own pre-existing and sometimes very stubborn plumbing systems.
Yes.
I mean, a first marriage is a startup, but a second marriage is a merger.
Yeah.
You are bringing in this massive web of pre-existing financial histories.
Okay, let's unpack this.
Yeah.
Because going into a second marriage without a financial plan isn't just like a minor oversight.
No, it's a huge risk. We are talking about existing property ownership, retirement savings that have been compounding for decades.
Decades before you even met your new spouse.
Right. Plus, complex investment portfolios, business ownerships, and the very real expectation of inheritances for children from prior relationships.
Navigating a complex corporate merger between two fully operational legacy companies requires serious due diligence.
Absolutely. You've got distinct company cultures, existing shareholders.
Which in this case means children from previous relationships.
Exactly. And you have entirely different balance sheets.
Not to mention existing financial obligations. I mean, one partner might be paying alimony or child support.
Or still paying off a massive medical debt from a previous chapter of their life.
Yeah, it's a lot of baggage. And I don't mean that in a negative way. It's just financial gravity.
What's fascinating here is that protecting these assets isn't about anticipating a divorce.
Right.
Or, secretly expecting the marriage to fail. That is the biggest misconception people have when they hear the words asset protection.
People always jump to the worst case scenario.
Totally. But it is actually about preventing default state laws from making deeply personal, life-altering family decisions on your behalf.
So if you do nothing, I'm assuming the state just steps in and applies a generic formula, right?
Yes, exactly.
Which sounds like a recipe for disaster. Let's say you just get married, merge the families, cross your fingers, and then one spouse passes away unexpectedly.
The state steps in using intestacy laws.
Intestacy laws.
Right. And for anyone unfamiliar, intestacy is just the legal term for dying without a will. State inheritance laws are a very blunt instrument.
They don't care about your specific family dynamics.
Not at all. They use a rigid default formula to distribute assets when someone dies. And that mathematical formula might distribute your wealth in a way that is wildly different from what you intended.
Which creates immediate, explosive conflict between the surviving spouse and the children from previous marriages.
Exactly. I mean, imagine a scenario where a state formula accidentally disinherits a biological child because everything automatically went to the new spouse. Or, conversely, the default laws might force a surviving spouse out of the family home because the stepchildren legally inherit a controlling percentage of the property.
And they decide they want to sell it immediately.
Right.
A situation where the new spouse is literally evicted by their stepchildren because nobody bothered to write down a plan is a complete nightmare.
It happens more often than you'd think.
And it brings us right into the absolute thick of it, really. The dilemma of blending.
Because those default state laws are so rigid and blind to nuance, couples have to make deliberate, often very difficult choices,
Yeah, about their day-to-day financial structure to protect everyone involved.
which almost always centers around the central struggle for a blended family, which is how to define fairness.
Well, I want to push back on this concept of fairness for a second. Fairness feels like a trap.
How so?
Well, it sounds nice in theory, but in practice, balancing those scales is incredibly emotionally fraught.
Oh, absolutely.
You have a parent who desperately wants to protect the inheritance of their children from a first marriage. I mean, that is a primal instinct.
It really is.
But at the same time, they deeply love their new spouse
Yeah.
and want to make sure they are cared for and not left destitute.
Right. It's a huge emotional tug of war.
So how does a couple even begin to practically structure their bank accounts to reflect those conflicting priorities?
Well, the guide explicitly notes there is no universal solution.
Which is honest, but daunting.
Very daunting. You have to look at the spectrum of approaches for combining finances. On one far end, couples merge every single account. Everything goes into a giant pot.
Okay.
On the other far end, couples keep absolutely everything separate, down to sending each other mobile payments for half the grocery bill.
Right, the roommate model, basically.
Basically. But for blended families, the most effective practical approach is usually the hybrid model.
So like a yours, mine, and ours system.
Exactly. The hybrid model typically involves setting up joint household accounts for shared expenses.
So that's the mortgage, groceries, utility bills.
Yeah, and maybe a shared emergency fund. But alongside that, you maintain separate personal savings and individual retirement accounts.
Okay, that makes sense.
And you clearly document the ownership of investments that existed prior to the marriage.
You are basically creating a financial buffer zone.
That's a great way to put it.
I imagine it works by sitting down and deciding on a proportional contribution to that middle pot.
Right. It provides the necessary flexibility to operate as a unified household on a daily basis while legally protecting premarital assets.
So how might the numbers work in real life?
Well, you might decide that, say, 60% of both your incomes goes into the joint account for the household, while 40% stays in your individual accounts.
Right.
It allows you to say to your children, hey, your inheritance is secure in this separate account, while saying to your spouse, our daily life together is fully funded in this joint account.
I love that. Think about your own situation for a moment. If you were merging your life with someone tomorrow, what would your ideal hybrid model look like?
It's a great exercise.
How much would you put in the shared pot, and what would you feel the absolute need to keep in a separate vault?
It's a revealing question for anyone listening because it forces you to confront your own financial insecurities.
It really does. But figuring out that daily financial structure, setting up the 3 checking accounts, is really only step 1.
Yeah, just the beginning.
To actually enforce those personalized choices long-term so they hold up in a court of law, you have to use specific legal guardrails.
The big 3, as they are often called in estate planning: wills, beneficiaries, and trusts.
Okay, let's start with wills. The source points out a massive, terrifying mistake people make.
Assuming an old will still functions as intended.
Yes. Let's say you wrote a will during your first marriage. You get divorced, you meet someone new, you get remarried.
If you don't update that document immediately, your old will might still list your ex-spouse as the primary beneficiary of your estate,
That is why.
or the executor of your assets. An outdated will can unintentionally exclude your new spouse completely, or any new children you bring into the family.
So you have to update guardianship instructions, who your executor is, and the specific property distribution the moment that ring goes on your finger.
Immediately, do not wait.
But here's where it gets really interesting. You can go to the lawyer, draft an ironclad, beautiful new will that splits everything perfectly between your new spouse and your kids.
Yep.
And it could be completely, entirely useless if you forget the second guardrail, which is beneficiary designations.
This is where so many people mess up.
The guide specifically notes that many of your most valuable assets bypass a will entirely, like life insurance policies, pension plans, retirement accounts, payable on death bank accounts.
They completely bypass the will.
I was genuinely shocked by this. So basically, a beneficiary designation on a random 401k form from 20 years ago is a private contract that bypasses the court entirely.
Yes. It will override your will every single time.
That is terrifying.
A will has to go through the legal system, right? It goes through a process called probate. Probate is basically the court process of proving a will is valid and then administering the estate.
Right, which takes time.
Exactly. But a beneficiary designation on a retirement account or a life insurance policy is considered a direct private contract between you and the financial institution.
So they don't even look at the will.
Not at all. When you die, that company looks at the form on file, and they cut a check directly to the person named on that line. They do not care what your will says.
Wow.
They do not consult the probate court. So if your ex-spouse's name is still on the beneficiary line of your life insurance policy, they are getting that money, regardless of what your current will dictates.
It's like having a high-tech security system on your front door but leaving the back window wide open.
Exactly. You have to secure both.
Even if you get the will right and you update the beneficiaries, we still haven't solved the fairness dilemma, the tug of war between